Good afternoon, everyone. My name is Lauren Williams. I'm Adult and Community Services Manager for the Columbia Public Library, which is part of the Daniel Boone Regional Library System. Welcome to today's Lunch and Learn, where we'll be learning about the role of judges in our state and on a broader level. Today's Lunch and Learn is co-hosted by the library and the League of Women Voters of Columbia Boone County. Before we begin our program, and I turn things over to the League to introduce our speaker, I have just a couple of housekeeping items. To ask questions of our presenter today, as usual, we'll be using the chat feature of Zoom. So if you hover over your Zoom window with your mouse, you should see that chat icon. It looks like a speech bubble and other tools at the bottom of your screen. If you're using a computer, if you're on a tablet or a phone, just tap in the middle to get those menu items. If you want to unmute to ask your question at the end of the presentation, or we've got a couple discussion questions at the end, you can use the raise hand tool, which is right next to the chat icon on your Zoom toolbar, and that will let me know that you'd like to be unmuted to ask your question. But as always, you can put your questions in the chat. We are recording this presentation today, and it will be available in the next day or two on both the League's YouTube channel and the library's YouTube channel for future viewing. And now I'd like to welcome our moderator, League of Women Voters of Columbia Boone County President Barbara Hoppe. Thanks so much, Barbara.
Thank you, Lauren, and thank you to the Daniel Boone Regional Library for co-hosting these Lunch and Learn programs. I'm really pleased today to welcome Dr. Anthony Simon, Director of Civic Education for the Missouri Bar, to talk with us about the role of judges. Dr. Simone has been nominated twice for the Sandra Day O'Connor Award for the advancement of civic education. He's past president of the National Association of State Judicial Educators and has served on the board of directors for 7 years. After earning his JD and PhD from the University of Tennessee, Dr. Anthony Simon spent over 20 years teaching American government and constitutional law in the university setting, first at Missouri State University and then at Dalton State College in Georgia. In that time, he was given the Missouri Governor's Award for Excellence in Teaching and was nominated 3 times for the Carnegie Foundation U.S. Professor of the Year. During that time, he also created materials for teachers and students in coordination with CNN and ABC News. And then after leaving teaching, he spent 6 years as manager of judicial education for the Supreme Court of Missouri. And then in 2017, became the director of civic education for the Missouri Bar. And so that's how he's coming to us today. He and his wife, Shantae, have a 9-year-old daughter, Mary Margaret, and a 2-year-old golden retriever named Noodle. So it's nice to have a well-rounded speaker. So before I turn the program over to Dr. Simon, I just want to remind people, as Lauren indicated, if you want to interact during the discussion, raise your hand or enter other maybe curious questions about judges in the chat, and we'll try to get to those. And with that, I'll turn the program over to Dr. Simon.
Thank you so much, Barbara. I am going to share my screen. I am going to get rid of the image I can see of myself, because that is a total distraction. And finally, I am going to do that. Okay. Thank you for the opportunity to be here to talk about the Constitution and judges, something that matters to me very, very deeply. Now, rather than spend an hour giving you an entire list of components of the role of a judge, What I thought we would do today is focus on a case study that illustrates nicely what judges do. Now, I'm going to start with a diagram that you're probably very familiar with. Our three branches of government created by the Constitution, separation of powers, are the legislative, the executive, and the judicial branch. Legislative branch writes the laws. Executive branch enforces the laws. And the judicial branch applies and interprets the laws. Now, most people have a pretty solid understanding of the role of legislatures and the role of executives, but there is less of an understanding about the role of courts. Legislators and executive branch officials, they make decisions based upon their own beliefs, their own policy preferences, and what public opinion says. That is how they were created. Judges, however, are different. Judges are supposed to follow the law. Courts should do what the law requires, not what public opinion says. This is something that my students used to marvel at. They would be like, you mean the judges aren't supposed to rule the way the people want them to? No, they are supposed to rule according to the law. They are not supposed to rule in a way that other elected officials expect them to. And, you know, in recent years, we've seen presidents express great frustration that their judges that they appointed are not ruling the way they want. And frankly, the framers never intended judges to rule the way the presidents wanted them to. Not even what the judges would personally prefer. This is one that we're going to talk a little more about in the next few minutes, but this is something I want you to bear in mind, that courts are supposed to do what the law requires, and that may come in conflict with what the judges would personally prefer. This sometimes means that judges must make some pretty unpopular decisions. What we're going to do today is we're going to look at a case when Justice Anthony Kennedy of the United States Supreme Court faced a conflict between his personal values and the law, and how he resolved that conflict. The case that we're going to be talking about involves freedom of speech. So this case starts at the 1984 Republican Convention in Dallas. A guy named Gregory Johnson is there, and he burns an American flag to protest the Reagan administration's policies. Johnson, who is pictured here, was arrested for violating a Texas law against desecrating a state or national flag. Now, I'm going to emphasize something here because people frequently misunderstand what's going on with this case. If Johnson had been arrested for setting a fire in a public place, he wouldn't have had a constitutional leg to stand on. But the law that he was arrested for violating and prosecuted for violating says that it will be a crime to desecrate, to deface, damage, or otherwise physically mistreat in a way that the actor knows will seriously offend one or more persons likely to observe or discover his action. So the law that he was accused of violating is one that made it a crime to engage in an offensive action. A jury did find it to be offensive and found Johnson guilty. The trial court sentenced Johnson to a year in prison and ordered him to pay a fine of $2,000. Johnson appealed his conviction. There you see Johnson with his lawyer, the infamous William Kunstler. Okay, so what does that mean to appeal a conviction? An appeal means that he asked a higher court to reverse the decision of the lower court based upon an alleged legal error that was made by the lower court. Here's the path of an appeal. This is the way it unfolds. Almost every case starts in a state trial court. Then that is appealed up to the state appellate court. Some cases make it up to the state Supreme Court. And if the state Supreme Court makes a decision in which they provide an interpretation of the United States Constitution, that can be appealed to the U.S. Supreme Court. So Johnson argued in his appeal that the law in question violated his First Amendment rights. And the First Amendment is one that is filled to the brim with important provisions. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Johnson, in his appeal, focused on freedom of speech. And he said, look, I was burning the flag to show my opposition to government policies. This is political speech, and political speech is protected by the First Amendment. In fact, it is at the heart of the First Amendment. The appellate court was not persuaded and refused to overturn Johnson's conviction. Johnson then appealed his case to the highest court in Texas. Johnson once again presented his argument. The law under which he was convicted violated the First Amendment freedom of speech. The highest court in Texas agreed with Johnson. People are always surprised when they learn that the Texas Court of Criminal Appeals said Johnson's right. The court said, look, Johnson is choosing to be provocative, but the First Amendment protects his right to be provocative. His political expression is protected. The court stated the right to differ is the centerpiece of our First Amendment freedom. As I indicated, a decision of a state court interpreting the Constitution can be appealed to the United States Supreme Court. That is what Texas did here. Appealing to the U.S. Supreme Court and arguing that its highest court misinterpreted the First Amendment. The United States Supreme Court agreed to hear the case. The issue the Supreme Court had to consider in Texas versus Johnson was whether the Texas law making it a crime to burn a flag because it was offensive violated the First Amendment. The Supreme Court was intensely divided on this issue. Now, 4 members of the court firmly believed that flag burning was protected. The 4 were William Brennan, Thurgood Marshall, Harry Blackmun, and Antonin Scalia. This was an interesting combination of judges. Brennan and Marshall, as you may know, were liberal lions at this time. And so it's not surprising that they came out on this side. Harry Blackmun had been an appointment of Richard Nixon but with every year had become more and more liberal. And then finally, Antonin Scalia had only been on the court for a couple of years, but he was already establishing himself as a leading voice of the conservative wing. And yet this coalition included conservatives like Scalia and liberals like William Brennan. As Justice Brennan wrote, if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. These four judges made the argument that is exactly what's going on here. The state of Texas has made it illegal to burn a flag because it finds that action offensive or disagreeable. Now, four members of the court firmly believed that flag burning was unprotected. This group included Chief Justice Rehnquist, Justice Byron White, Justice John Paul Stevens, and Justice Sandra Day O'Connor. Again, a very interesting coalition of judges on this side. William Rehnquist at this point had been on the court for 15 years, had been elevated to the position of Chief Justice, and was known as a voice of conservatism. Byron White had been appointed by John F. Kennedy, and he was kind of moderate in the middle. John Paul Stevens was, at this point, one of the more liberal members of the court, and usually found himself on the side of judges like William Brennan and Thurgood Marshall. And yet on this one, he went the other way. And then finally, Sandra Day O'Connor had been on the court for less than a decade, was considered a moderate, and she joined this group. The thing that William Rehnquist, Byron White, John Paul Stevens, and Sandra Day O'Connor's husband had in common is they had all fought in World War II, and they had fought for that flag. And John Paul Stevens, representing this position, wrote, "If liberty and equality are worth fighting for, and our history demonstrates that they are, it cannot be true that the flag that uniquely symbolizes their power is not itself worthy of protection from unnecessary desecration." For John Paul Stevens, the ideas that that flag stood for were worth protecting, and therefore that flag was worth protecting. So we have an evenly divided court. It would come down to one justice, Anthony Kennedy. Anthony Kennedy had not been on the court for long at this point, just a couple of years. Kennedy had become a member of the court after Robert Bork had been defeated by the Senate. And he was still kind of feeling his way about where he would fit on the ideological spectrum. Kennedy's position was not simple. On one hand, he had personal revulsion for the act of burning the flag. He regarded burning a flag as one of the most deeply offensive things that you could possibly do. On the other hand, Kennedy believed the First Amendment and the decisions interpreting the First Amendment protected even offensive speech. So, Justice Kennedy's personal feelings and his professional judgment were in conflict. Kennedy wrote a separate opinion to explain his decision. I am going to read to you from this opinion, and I want you to listen closely, and I want you to tell me whether or not you find Kennedy's reasoning convincing and whether you believe he is making the right decision. Okay? He writes, I write not to qualify the words Justice Brennan chooses so well, for he says with power all that is necessary to explain a ruling. I join his opinion without reservation, but with a keen sense that this case, like others before us from time to time, exacts its personal toll. This prompts me to add to our pages these few remarks. The case before us illustrates better than most that the judicial power is often difficult in its exercise. We cannot here ask another branch to share responsibility, as when the argument is made that a statute is flawed or incomplete. For we are presented with a clear and simple statute to be judged against a pure command of the Constitution. The outcome can be laid at no door but ours. The hard fact is that sometimes we must make decisions we do not like. We make them because they are right. Right in the sense that the law and the Constitution, as we see them, compel the result. And so great is our commitment to the process that, except in the rare case, we do not pause to express distaste for the result, perhaps for fear of undermining a valued principle that dictates the decision. This is one of those rare cases. Our colleagues in dissent advance powerful arguments why respondent may be convicted for his expression, reminding us that among those who will be dismayed by our holding will be some who have had the singular honor of carrying the flag in battle. And I agree that the flag holds a lonely place of honor in an age where absolutes are distrusted and simple truths are burdened by unneeded apologetics. With all respect to those views, I do not believe the Constitution gives us the right to rule as the dissenting members of the court urge, however painful this judgment is to announce. The case here today forces recognition of the cost to which our beliefs commit us. It is poignant but fundamental that the flag protects those who hold it in contempt. For all the record shows, this respondent was not a philosopher and perhaps did not even possess the ability to comprehend how repellent his statements must be to the Republic itself. But whether or not he could appreciate the enormity of the offense he gave, the fact remains that his acts were speech in both the technical and the fundamental meaning of the Constitution. So I agree with the court that he must go free. People have strong reactions to Justice Kennedy's decision to rule that flag burning was protected by the First Amendment and to overturn Johnson's conviction. Some criticize Kennedy for making a decision that violated his most fundamental beliefs about right and wrong. I used to teach this case in the classroom as an example of what courts do. And there would be students who would hear what Kennedy had to say, and they would respond with outrage. They would say, "Are you kidding me? This guy understands perfectly the difference between right and wrong. This guy understands perfectly how offensive this is, and yet he turns around and extends constitutional protection to this?" Others applaud Kennedy for making a decision based upon the law rather than his own personal beliefs. Then I would have other students who would raise their hands and they would say, "No, this is exactly what I want court to do. This is exactly what I want a judge to do. I want a judge to make a decision based upon the law, not what they personally believe. I challenge you to answer this question. What do you think? I'm going to return to this here in a few minutes when I finish the presentation, and I want you to be ready to put forth your ideas about Kennedy's decision. Now, here's the bigger picture. Here's the thing. If Justice Kennedy had been a legislator, a governor, or the president, he could have made his decision based upon what he himself thought best, or based upon what the majority of the people wanted him to do. As a judge, though, he had an obligation to make his decision in a different way, with the law as his priority. Now, some people contend that the method used to select a judge may influence how that judge does his or her job. So for the rest of this presentation, I would like to talk about this question. How are judges chosen? And there are a number of different ways, and I'm going to tell you about them, and I'm ultimately going to ask you about them. One way is provided by the Constitution, the constitutional method for the selection of federal court judges. Article 2, Section 2 states, the president shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court and all other officers of the United States. Article 3, Section 1 goes on to state, the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. So, the constitutional method for the selection of federal court judges, they're nominated by the president, they are voted upon by the Senate, and then they hold that position for as long as they want to hold it. Why did the framers choose this method of selection? If judges are expected to strike down legislation supported by the people but violative of the Constitution, and that is one of the things that the framers wanted. They wanted judges to rule unconstitutional legislation, even if it's supported by the people. If it violates the Constitution, then they wanted judges striking that legislation down. If that's what they wanted, then it was necessary for judges not to be required to face an election. Judges who fear being voted out of office by an outraged public may choose to interpret the Constitution not as it was intended, but in a way that will placate the masses and maintain their job. A lifetime appointment gives the judges independence to apply the Constitution without fearing the consequences of an unpopular decision. And as we have seen with the flag burning case, sometimes applying the Constitution gives us a result that is not going to be popular. Those who oppose the lifetime appointment given to federal court judges ask, where's the accountability? Any other public official must face the voters and can be removed via the voting booth. Why are federal judges exempt from this? These critics contend that the lifetime appointment given to federal judges is inconsistent with the constitutional system of 3 co-equal branches of government and, in fact, creates judicial supremacy. So that's one method. Here's another. Elections. The reforms of the Jacksonian era emphasized the need for popular involvement with government and accountability of public officials to the people. One of these reforms from the Jacksonian era involved judges being elected by the people and serving a limited term. To serve on the bench, judges would have to get the approval of the voters. This became a popular method of judicial selection in the states, and it continues today. In fact, I will tell you that most of the judges in Missouri are elected. Some people love this. Some people say this is the way it should be, that if judges are going to be making these kinds of important decisions, then the people need to be involved in determining, in voting for who judges are going to be. Others say, well, the problem is it injects aspects of politics into a process that is supposed to rise above politics. So here's the third one. So we've got the federal method in which you are appointed for life, or as long as you want to be there. It's not a life sentence. And then we've got the idea of elections. In 1940, Missouri was the first state to reject both the "you're there forever" judge method and the "election is good enough for other branches, why not you" method. The Missouri Plan, also known as the Nonpartisan Court Plan, created a method for judicial selection that was an attempt to incorporate the advantages of other methods while avoiding their flaws. I'm going to tell you quickly, I'm going to go over how the Missouri Plan works. When a judicial vacancy occurs, anyone who is qualified and interested can submit an application. The application is comprehensive and lengthy, and that is to assess the qualifications of the applicant. The applications go to a judicial commission. The judicial commission is composed of a judge, attorneys identified by the bar, and citizen members appointed by the governor. The Judicial Commission studies the applications and interviews those who have applied. And pictured here is one of the applicants in previous years being interviewed by the commission. The Judicial Commission then provides a list of the top 3 possibilities to the governor, who makes the final decision. And I wanted to give you an idea of the kind of people that are put forth. And so I wanted to provide you with these pictures representing the choices that were given to Governor Greitens in 2017 for the replacement of Supreme Court Judge Rick Titleman. They are Missouri Court of Appeals Judge Lisa White Hardwick, St. Louis Attorney Benjamin Lippman, and Jackson County Circuit Judge Brent Powell. So the governor makes a choice and the judge takes a seat on the bench. And shown here is Brent Powell, who was selected to the Supreme Court in 2017. He is standing there at the Supreme Court and being administered the oath of office by Chief Justice at that time, Zell Fisher. After approximately a year, that judge is voted upon in a retention election in which voters are asked whether the judge should remain on the bench. If retained, the judge serves a term of 12 years on an appellate court and 6 years on a trial court. At the end of that term, the judge can seek retention again and will run in a retention election. I always, this time of year, or actually last month, I always have friends, family who come to me and they say, I went to vote for governor and I got bombarded by this list of should this judge be retained? And I tell them, this is your opportunity to participate in the process whereby you can help shape what the bench looks like. And as you all know, they are literally asked, voters are literally asked, should Judge Lisa Page be retained, or should Judge Patricia Breckenridge be retained? To help voters make an informed choice, the Missouri Bar surveys attorneys on judicial performance, and there you see Judge Breckenridge's ratings. And the League of Women Voters also participates in this process. In Missouri, all judges must retire at age 70. So the Missouri plan was used to select the first woman to serve on the Supreme Court of Missouri, and that was the great Ann Covington, and was used to select the first African-American to serve on the Supreme Court, the equally great Ronnie White. And in May 2021, Governor Mike Parsons exercised his authority under the Missouri Plan and appointed Robin Ransom, the first African-American woman on the Supreme Court of Missouri. Now, even though it's called the Missouri Plan, do all courts in Missouri use the nonpartisan plan to select judges? No. This map indicates the counties, the cities and counties that do. All right, first of all, it's used to select all members of the Supreme Court. Second, it's used to select all members of the 3 courts of appeals and the trial courts in the following counties: St. Louis, Jackson, Platte, Clay, Greene, and in the city of St. Louis. Now, when you go through and you total up the judges who are selected under the Missouri Plan in Missouri, it comes out to be less than 40%. As I indicated to you a little while ago, most judges are still elected using the election method. Now, I'm going to close by saying, think back to the example of Anthony Kennedy and your ideas about what you expect of a judge. My final question for you as we move to the next part of this presentation: which method of selection produces the kind of judge that you want? So is it okay, Barbara and Lauren, if I ask my questions of
Yes,
the audience now?
yes, go ahead.
My first question to you is, what did you think of Justice Anthony Kennedy's vote in the flag vote? And what did you think of his explanation for that vote?
So people can either raise their hand and Lauren will let you come in to speak, or you can put your response in the chat. And Dr. Simon can see that, or I can say it, so we can have an interaction that way. Do you have hands up, Lauren? I can't.
Not yet. People are being shy.
Okay. Well, there, we'll give them a chance to respond in the chat. Please respond, at least in the chat, so we can have a discussion. But there is a related question that you might want to answer, giving people time to put the responses in, and that is, if you would explain what is stare decisis and its role in judicial decision making, that might be helpful.
Stare decisis is roughly translated, let the decision stand. And it means that the courts should follow previous decisions unless there is a compelling reason for overturning it. And the example that I always think back to is in the late 1800s, the court decided in Plessy versus Ferguson that separate but equal was a totally legitimate doctrine, And in 1954, in Brown versus Board of Education, the Supreme Court overturned that precedent and said, no, this court was wrong when it made that decision in Plessy. And today we rule that separate but equal is unconstitutional in a school setting. So it's based upon the idea that one of the most important aspects of the law is certainty, and that courts should follow previous decisions. Now, here's the thing. It is, so we follow the previous decisions, except when we don't, except when we say, you know, we are prepared at this point to say that that previous decision was wrongly decided. And we saw an extraordinary example of that this summer when the Supreme Court ruled that Roe versus Wade was improperly decided and overturned that decision. When the court does that, when the court departs from stare decisis, it is either going to be seen as very, very wise in rejecting a decision that needs to be rejected, or it is undermining the credibility of the court by making the decisions look like it is simply a product of what individuals occupy a seat on that court. I will leave that to our listeners to decide which is applicable here.
Okay, let's I think we have some responses now. Rosie Geyser says, agree with Justice Kennedy. Let's see, Ruth Millage, when it comes to hate speech, I can't support the thinking of Justice Kennedy. Hate speech. So how do you separate hate speech from free speech? I guess maybe that's an issue. And then there's, let's see. I'm going to punt on your answer, Diane Schuler. I'm going to punt on answering your question by asking another. How would the concept of original interpretation of the Constitution fit into Kennedy's approach and decision? Maybe we can stop there, and there's more, but
well, it depends on how you define original interpretation of the Constitution. If you mean what was the understanding of freedom of speech at the time of the writing of the Constitution, then that is probably, things were pretty conservative back then. And so if you're going strictly by what was the understanding in 1787, probably you're gonna give the government quite a bit of authority to legislate in this area. On the other hand, if you are going with the original understanding of the role of the court and the idea that the court should not just rubber stamp decisions of legislative bodies, and that they should look to the essence of the constitutional rights being litigated, I think, in all honesty, I think Kennedy would come out pretty good on that front. So it really, as so frequently happens, it depends on how you define your terms.
do you want to say a little bit more about interpreting the Constitution as a living document versus static at the time of not evolving to the change in society?
Yes, I would be happy to. I always think back to Antonin Scalia saying at one time, it's not a living document, it's a dead document. It's a document that was written in 1787. And that's the way we should look at it, with the exception of the amendments. We have formally amended the Constitution, then we can make the change. There have been other judges who have said, no, it is not a dead document. That is the last thing in the world the framers would have given us, was a dead document that is forever locked in 1787. And they wanted a constitution that would last for centuries. In order to do that, judges have got to interpret that document that was written in 1787 according to the challenges that we face in 1887, in 1987, in 2087. So again, this is one that is, I'm not going to say that there's a right way or a wrong way. It is up to each individual to make that decision for themselves.
And that would also go to the spirit of the law versus the letter of the law, dualism or tension.
Absolutely. And, that's one of the questions that judges ask. They say they look at the provision in the Constitution and they ask, why was this put in here? What value was this designed to ensure? And how can we apply this at this current time? I want to ask my second question now.
Oh, could I do, there was one more comment
Please.
that we could get to and then go to the second one. Marjorie Sable, I can't remember when a judge was not re-elected. It does put the responsibility on the voter to look them up. Oh, okay. So is this your second question? I think this goes to your second question. It does put the responsibility of the voter to look them up and find out their position on things. And most voters seem to just vote yes without knowing anything about the judges. Okay, so that's the second. Let's go ahead.
No, and it's a good point. It's a good point. And, I have had people articulate to me such different ideas on this. Some of them have told me I vote yes on everybody. By the same token, I've had people say I vote no on everybody. And that just blows. I guess it's because I know and work with these judges. And I'm like, what? You voted against this person? Why? And they were just like, I was in a bad mood. And I was like, did you study what they had done? Did you look at the materials that the bar and the League of Women Voters provide? And they were like, nah. I would say it does put the responsibility on the voters. And my hope is that as we move forward, that voters will take this responsibility more seriously and will avail themselves of the resources that they have and make informed choices about these judges. Here's the thing. Under the Missouri Plan, to get on the court, these judges have got to go through just an extraordinary process where they are questioned, where they are challenged. And, the argument can be made, the fact that we aren't having a lot of judges get voted off, it might not be a bad reflection on voters, but rather it might be indicative of the fact that the process is working well and the people who are getting on the bench through the Missouri plan are really, really impressive, and they should be voted to be retained.
So, I was gonna say, I know, we refer people, and on our voters guide, tell people to look at the survey from the Missouri Bar and those documents. But I know lots of people who are very educated and very generally well-informed will contact me and just say, who should I vote for? Who should I not vote for? And it would be helpful. I think what they need more is maybe knowing some key decisions that each judge has made. That might be good for us to list in the future, so people have a little more detail of how these judges decide important cases and why. What do you think about that?
There's a part of me that really likes that, Barbara. But there's another part of me that knows how complex these decisions are. And if you just list the decisions that they made, voted in favor of flag burning, voted in favor of overturning a death penalty conviction, those can look really, until you look at the entirety of the decision, there's a danger in that as well. The committee who evaluated the judges are just people too. Boy, I agree. But I will say that the choice to bring together the people who engage in this review process, it's painstaking, and it is designed to get people who understand courts and understand what judges do and understand the importance of this, and they bring those things to the endeavor. Can I ask my question now?
Yes, please.
Okay. If we could just, I told you about 3 different methods for the selection of judges. I talked about the federal lifetime appointment. I talked about straight up elections, and I talked about the Missouri plan. If we could only have one way of choosing judges in Missouri, what would it be? From your perspective about how you want the courts to run, what would be the one way that we should choose judges?
So people can either raise their hands, or let's say we're getting Missouri plan from quite a few people. Let's see, got another response here. Missouri voters have never rejected an appellate court judge. The only restriction has been retirement at age 70. And then we have another Missouri plan. And then I'll say, I think the Missouri plan is great, and it's been a template for a good selection process, throughout the country. Although for locally, like for choosing judges locally, I do like the direct election process because they're closest to the public and we know them best.
I have heard that argument articulated by some very impressive people, Barbara. And so, yeah, I see where you're coming from on that.
We have some more people weighing in here. Decisions of the governor on appointments may be partisan, just as when citizens vote for against judges. So that is the concern about governor appointments. But we do have the judicial commission that is sort of a more rounded. You can speak to that. That recommends the 3. They narrow it down for the governor, so he doesn't just pick anyone. out of the state. They have to be selected, but you can say more about that. There's a question, Tony, do you have ideas on how to depoliticize the US Supreme Court too?
Okay. First of all, with regard to Winifred's question about you can still have politics worming its way in under the Missouri plan. Winifred, you're exactly right. You could still have politics at work and a governor choosing somebody he or she wants politically. Now, here's the thing that the Missouri plan does. That person takes their seat on the bench, but they will come up for a retention election at the next election. And so if it is a purely partisan nightmare where it's like, oh my gosh, how can this governor have inflicted this on us? The people have the ability to go and vote that person off. Do I have ideas on how to depoliticize the U.S. Supreme Court? Actually, there is a very interesting idea that has been circulated in the last year. Part of the problem with the way the U.S. Supreme Court works right now is you never know when a slot is going to open up, and you never know when the next one is going to be. And as a result, what happens when a position opens, it becomes partisan warfare to try and get your person on, and not only get your person on. Now it's a matter of, oh, let's find the youngest possible person that we can who's going to be on the court for the next 40 years. And there have been some people who have said, you know what we should do? We should have a situation where every 2 years, somebody rotates off the court and the president gets to appoint a member to the Supreme Court. And the people who get on the Supreme Court would serve an 18-year term. And so what would happen is we would know, okay, well, we've got this appointment coming up, and then we're going to have another appointment coming up in 2 years. And there are some people who say this might take some of the intensity out of it. That might take some, because it is so uncertain, because we don't know when the next one will be coming up. It leads to a desperation. It leads to this kind of, oh my gosh, we have got to win here, and we've got to win big. And there are some people that say that is one of the ways of taking some of the politics out of it, taking some of the intensity out of it.
So how would that change take place? The mechanics of it.
I think that we would have to amend the Constitution. And that is, as we know, no easy feat. But there are some people who say, you know, one of the things that we have seen in our history is that the people, while we don't amend the Constitution with great regularity, we do amend it when we need to. And there are some people who say, with what we have right now with the Supreme Court, there is a need for change.
Okay, thank you. A couple more things. Let me see. Nancy Copenhager says, it seems unfair to me that only some counties can choose to use the Missouri court plan. Can you talk a little bit about that?
Actually, Nancy, it's not a situation where we have said, oh, well, Platte County, you get to do it, but Boone County, you don't. Any state, any county can start the process and adopt the nonpartisan court plan in their county. This happened in Greene County the most recently, and they said, look, we want this. We want to take it out of the realm of the political, and we want to bring the nonpartisan court plan. So, the people at any point can always say, if enough people say, we want this, let's put it on the initiative, let's put it on the ballot, and let's vote on it, they can make that change.
And then there are two more questions, one in chat and then one early on the end of chat and the one early in chat. Elena Vega asks, how about removing the very political Federalist Society out of the Supreme Court appointment process? Wouldn't that easily take the intense political tone out of the process?
I appreciate where you're coming from on that, Elena. I have a hard time, though, saying this group will not be allowed to participate in the process. I would say that if you are concerned about the Federalist Society, then make sure that there is, because they tend to be on the conservative side. I think the answer is allowing, or encouraging the creation of a society on the other side. I'm very skittish about the idea of saying you will not be allowed to participate. You will not be allowed to advocate. I think the answer is articulating a vision that is different from the group that you find problematic.
And we have one question that goes back to the first program on the case study that I thought was a really interesting question and sort of timely. And it was our books, library books, protect a protected form of free speech, thinking about restrictions here in Missouri and elsewhere.
The argument can be made that yes, they are. Yes, they are. And now here's the thing about protected free speech. We have always recognized that limits can be imposed on speech. So yes, library books are covered by the idea of free speech. Limitations on free speech are ones that that we have accepted, and ultimately, I would argue, the courts are the one who decide whether these limitations that are being imposed on library books are consistent with the First Amendment.
Thank you very much. We've come to a little bit over our hour, so we're going to have to close. I want to thank you so much for a very interesting, thoughtful, informative, and interactive program, and thank our guest participants for attending. Thank the library and Lauren for co-hosting this Lunch and Learn. This is recorded, and so it will be available on YouTube and on our website and the libraries. And just to remind people that our next Lunch and Learn is the second Tuesday in January 11th. And Shauna Hamilton, founder of the Boone County Community Against Violence, will be our guest presenter. So please join us then. And thank you so much, Dr. Simon, for this very interesting and important program. Thank you. Happy. And everyone have a happy holidays, safe holidays, and see you in January.
Thanks, everyone.
Take care.